Hi, Janice.
Hi, Anthony.
Today we're going to answer another frequently asked question. When does the executor tell the beneficiaries? I had to fix my emphasis there. Short answer is once the court process starts, usually shortly after death, and not immediately, not upon signing the will. So we usually get this question from somebody who's, about to sign their will and perhaps cutting somebody out, or, maybe somebody's not getting what they might have expected, and they're a little worried of when this person when that beneficiary or family member will find out.
So today we will discuss when does the executor notify the beneficiaries? What does an executor have to disclose to those beneficiaries? And then who else does the executor notify?
Cool. Let's get started. Okay, so when does the executor notify the beneficiaries? Again, it's not upon signing the will. It's not like as soon as you sign that, your executor turns right around and says, "Hey, Joey, you got cut out." I mean, I don't mean to laugh, but that would be kind of hilarious in a way for Joey, not for Joey.
Not for Joey.
So yes, this happens after you've passed away as part of the probate process, and I'll go into how and why in a little bit. But so. That awkward conversation, those awkward Thanksgiving dinners or whatever, that is not going to happen. It only comes up after you pass, yeah.
Okay.
And what does that look like? It's actually a formal court form notice that your executor or your probate attorney will mail to any beneficiary named in the will, just regular postal mail. So next, what does an executor have to disclose to those beneficiaries? What exactly does this form look like? What information is in there? So the reason some folks ask this is because they want to know, is Jack going to know that he got more than Jill, right? I mean, some folks are kind of worried
They
about
want to
that.
be, yep.
So the answer is no, not necessarily. That court form that I just mentioned that gets mailed to everybody is merely a list of all beneficiaries, so they all see it. They all see each other's names. But at least the way we do it is it's just a general description of what everyone receives, right? And it doesn't include a full copy of the will. So it's almost like just a summary form. And it'll say Jack, instead of saying Jack received $10,000, it'll say Jack received a cash bequest.
Yep.
And instead of saying Jill received my diamond bracelet, it'll say Jill received some tangible personal property. Right. So it won't necessarily specify who got what so that everyone can compare and bicker. And again, beneficiaries don't necessarily get the full will, although some might. We'll talk about that next. I just also want to point out that this is not the case with trusts. Trusts are completely private. Nobody gets to know anything if you don't want them to. So when you're doing your estate plan, if you're kind of weighing wills versus trust, and you're trying to figure out what the pros and cons are, that's one of the pros of trusts. Just you have a complete control over the dial of how much privacy you want and how much information you want disclosed.
That's nice. Then you wouldn't have to worry about most of this that we're talking about.
Yeah, for sure. Oh, it kind of wipes out this whole conversation.
Yeah.
So finally, who else does the executor notify? It's an interesting question. Basically, the rule is anyone who's next of kin. The technical term is distributee, but what it really means is whoever would have inherited under the state's default inheritance laws if this will didn't exist. And basically, there's a whole depth chart or order of priority under state law. It's cousins or uncles. It really depends on your individual situation.
Right.
If you're leaving everything to your friends, neighbors, and pals, and cutting out your next closest relation, which is a niece and nephew who you don't really talk to that much, your executor will have to notify them, the niece and nephew. That's part of the court process. They need to have the opportunity to say, "Hey, if this will didn't exist, I would get everything. So
right.
I'm the one who has a right to object to the will." Right. So yeah, if you cut out Jack and Jill, those estranged and not too friendly nieces and nephews, just know that they will receive notice. And when I say notice, this is slightly different from what we talked about before. The notice that goes to closest family members is not just regular mail; it's actually served on them.
Oh yeah.
Right. If you don't know what that means, just try to find it. What's a good legal movie?
Yeah.
American Gangster has a scene where Russell Crowe is served, and basically some dude has to approach you and hand you the paperwork.
Right, right.
And you do get a copy of the will. So, this is not just a mere, cash bequest general description. They get a full copy of the will. So yeah, that's who else the executor must notify. And again, circling back to the trust, if this is something you prefer to avoid, basically a trust avoids all this. So another reason why you might want to consider a trust.
Yep,
Yeah.
definitely something to consider.
Yeah, I think that's all we have today.
Okay. If you want to learn more, check out Anthony's book, The Solo Ager Estate Plan, available on Amazon. This just little tidbits, but the book goes into everything a little bit deeper.
Very good. Thank you, Janice. Thank you, everyone, for listening. And we're happy to answer any of your questions. Talk next time.
Talk soon.
Bye now.